there are legal and policy developments that are happening that are going to have an impact on the geospatial sector, because previously this sector has not been as focused on some of these issues. But I think that's going to start to change as these other technologies evolve and the geospatial information plays a role in them. Part of the challenge, in this community, because it's working across so many different sectors and so many different technologies that the data is being aggregated into, is understanding what those legal regulatory challenges are and helping your customer, your vendor, find a solution that works for you and works for them. Because keeping up with what laws evolving around artificial intelligence is going to be really important. With AI and everything being done sort of behind the scenes, it's going to be increasingly important, I think, to understand how your data is being used and who's using it, and one, to make sure that you're properly compensated for it, and two, that it's being used in ways that it's suitable for, both from a legal standpoint and from a business standpoint, right?
Hello and welcome to WGIC, the World Geospatial Industry Council. Our guest today is Kevin Pomfret, Partner Williams Mullen, Executive Director, Center for Spatial Law and Policy. Kevin, thank you so much for joining this conversation.
Thank you for having me.
It's great to have such an well-versed attorney in geospatial technology and industry who have been working for many decades in this industry. I would like to start my interview with one single question about the technology growth that has accelerated since the turn of the century and continues its exponential strides, right? As an attorney practicing in this industry, what are your general observations about the accelerated pace we see in this industry and also the allied technologies? And how are law and policy keeping pace with this exponential growth?
I like to say that the geospatial community was big data before big data was cool. And so it has been dealing with some of the issues that other technology sectors are, delving into now around the collection, use, storage, distribution of information in general. And I'm thinking AI, for instance, but issues around digital twins and other technologies. So I think it's an exciting time. I think the geospatial sector has a really, really unique perspective to take advantage of this and to contribute to the growth of the technologies. But I also think that, putting on my lawyer's hat, I do think there are legal and policy developments that are happening that are going to have an impact on the geospatial sector, because previously this sector has not been as focused on some of these issues. But I think that's going to start to change as these other technologies evolve and the geospatial information plays a role in them.
I want to take up a few questions around privacy, intellectual property, and licensing, but let's start with the privacy aspect of it. And how do you see privacy laws such as the GDPR in Europe apply to geospatial data? And how can businesses ensure compliance with privacy laws when handling geospatial data?
So I think one thing to appreciate about privacy laws like GDPR or CCPA in California, and frankly, a number of countries now have comprehensive data protection laws. The United States is one of the few that doesn't have a federal comprehensive law. A number of states have laws. But the interesting thing is that we've moved away from personal identifiable information as being what's regulated or protected to more broadly defined, personal information that's can be directly or indirectly linked to an individual with other data. And when you start thinking of privacy in those terms, then geospatial information plays a very important role because, as this sector knows, location data in all its shapes and forms is a great enabler to put on other types of information and possibly identify someone with a pretty high degree of confidence. And so I do think as these technologies evolve, I do think that privacy laws are going to be increasingly impactful on some of the applications that are being developed, particularly as geospatial products and services are being developed using data from a variety of sources, right? That's where the real power comes from, is to be able to bring in data from industry, from government, from individuals. And so that's going to be, I think, the real challenge for this community. How can it prepare for it? How can, organizations, whether they be businesses or government agencies, I think first of all is to understand what the law is and to not just assume that it doesn't apply to you. And also to appreciate that even if it doesn't apply to you, it probably is going to apply to some of your customers or vendors. True. And so they're going to have, requirements that they need to enforce contractually or otherwise, or it may be a hindrance in terms of how your customers can use your data, and you're going to have to work with them around issues around privacy and what I consider to be the other side of the coin on that, which is cybersecurity, information security. So if data is considered sensitive or important to be protected because it's either personal or for national security purposes, the other thing we're seeing developed are, increasing requirements both from a legal standpoint and a contractual standpoint around information security, protecting the data, letting people know if there's been a data breach. So this issue, again, the geospatial community has been big data for a number of years, but the law around data is evolving, and the geospatial community is going to have to keep up with that.
All right. Kevin, you and I have known each other for several years and revisited, but it's always good to revisit some of these aspects around intellectual property and licensing around geospatial data. What do you think are the key intellectual property concerns right now related to geospatial data, especially about copyright, patents, etc.? And how should a service provider handle licensing agreements for geospatial software or data, especially the third-party data?
So I think there are a couple of developments that are worthy of considering. One is, like I said, a lot of geospatial products and services are being developed by aggregating of different data sources and different data types, right? And that requires a good understanding of intellectual property law to make sure you understand who owns the new product or service that's being developed. Do you have rights in it, and what rights do you have? The body of rights could vary quite a bit. So that's one aspect that I think is really important. And I think we'll talk about license agreements and where that fits into the process, because that is an important component. The other aspect, I think, is the law that's developing around artificial intelligence, because a lot of the training data from artificial intelligence was based on scraping data off of websites and getting other sources of data. Some of it may have been subject to copyright. Some of it may not have gotten without approval. Some of it may be not considered quote unquote fair use, which is a legal term of art here in the United States and I think in other parts of the world. So a number of courts are looking at what copyright protection applies and how you can use it, and what the law, the law wasn't set up with copyright with sort of all the digital ways that data can be collected and used. So keeping up with what laws evolving around artificial intelligence is going to be really important. And then also, for instance, the U.S. Copyright Office and I think other copyright offices around the globe are also issuing guidance as to what intellectual property you can have in LLM generated content. And so there's a lot of work in the geospatial sector now around generating content around maps, but what intellectual property rights are associated with that are going to be really important. So those are the two big issues, I think, from the intellectual property standpoint for the geospatial community. I do think that licensing is going to play an important part of that, because you're going to need to make sure you get the rights that you want in the data if you're licensing it from another party. And then if you're licensing data to another party, you're going to need to make sure that you're only giving that party the rights that you want them to have. And understanding that around geospatial information is really difficult. So let me give you an example. There's so many different ways that information is collected. There's so many different types of geospatial information. There are so many different risks associated with geospatial information. And even intellectual property law applies differently to imagery than it does to maps, than it does to databases. So understanding all of that and the work that you're doing is going to be increasingly important to make sure data is an asset. Data is an organizational asset. And from a legal standpoint, you want to enhance its value and you want to mitigate against any risks. And that's That's going to be important. You do that in many cases through intellectual property rights and through licensing agreements.
Okay. Thanks for enumerating that. Kevin, WGIC is a member-based organization. Different type of geospatial industry players are part of these organizations. And from their standpoint, I'd like to understand what are the legal risks associated with the use of geospatial data and technology in various industries, for instance, construction, agriculture, urban planning, and because our members provide services to a range of these industries as well, right? So how can a business limit liability when relying on geospatial data for decision making or for operations?
So I think there are several ways that it can limit liability. I'll start with the second question first. So I think there are several ways. One is through contractually, is to make sure that when you're creating products and services or sharing data, that contractually you have it clear who's responsible for what. So a data license agreement or any sort of agreement, it just doesn't convey use rights or intellectual property rights in the data. It also requires the ability to understand who's responsible, how to mitigate risk, because unlike selling products and services, when you're licensing products and services, there's still joint rights and responsibilities back and forth, and that's what the agreement contractually needs to require. So making sure you have that spelled out in your agreement and you understand what the risks are could be is going to be very important. I think insurance is an important component. Making sure that you have insurance that covers your particular product or use or service and is adequate for that. And making sure if you have a customer that you are shifting liability to or risk to, that they have adequate insurance. There's a way to do that contractually as well. Certainly, quality control, quality assurance, policies and procedures all around the data. Again, the geospatial community has been doing this for years, so it understands that. But I think it needs to realize that in order for this community to grow, it's going to need to be working with others that are unfamiliar with geospatial, right? True. New sectors, new technologies, new applications. And so making sure that they understand, or at least they take the risk if they don't understand, is going to be increasingly important. And again, contracts are going to be part of that. Training is going to be part of that, making sure that you have training involved. Also, you need to understand, if you move into new sectors, you need to understand what the law is for those sectors, right? So for products and services geared to consumers, for individuals, generally the law is more protective of them and often will have a particular law or regulation in place to protect them that you wouldn't have in a B2B context, right? So understanding if your ultimate end user is going to be a consumer, what obligations you have there. So there's a litany of issues to consider. As a lawyer, I worry sometimes that I come across as too negative because I talk about risks and things, liabilities. Actually, all I'm doing, I'm a big believer in this sector. I started out many years ago as a satellite imagery analyst. As you've mentioned, I've been involved in this for a long time. Yes. But I see what's happening in other sectors, other technologies, and I think that this community, because of all that's happened over the past, certainly since the 2000s, but even over the past 5 or 10 years, it's fantastic. But with that opportunity comes responsibility, and some of that is understanding that. To your first question about whether, what the different risks are, I think that varies as well, right? Because if in the agriculture sector, you use different data, it's used, there's different precision, accuracy, timeliness, completeness types of data, different users than you would be in the digital twin environment, for instance, right? A digital twin environment is much more real-time applications. You're bringing in products and services from a number of different sources and combining it, and you're making very critical decisions where lives can be at risk, right? So those risks are greater than if you were in the agricultural sector, right? They're both geospatial, but they have geospatial components, but the risks are very different, and you can't just assume they're going to be the same, or you can't just assume that your agreements or policies or procedures are going to work as you move into a new sector. That's my sense. Also, their privacy risks will vary in terms of what the work that you're doing. So, and national security risks, and there's concerns around national security and exporting of geospatial data. So understanding what those risks are and being able to address those in your policies and procedures and your contracts through insurance are all things that you can do to better prepare yourself to take advantage of these opportunities.
Yeah, right. Thanks for that detail, Kevin. You mentioned about the risks, and the risks are always with respect to the following in terms of complying with the existing policy regulations in each country. And certainly every country has its own regulations. For instance, the FAA regulations for drones and zoning laws for US. Are there any regulations in your experience that geospatial and Earth observation companies often overlook? Is there something that you see in your clients?
I can't think of anyone in particular that they often overlook. But what I do see is I don't think they're often appreciative of the legal and regulatory obligations of their customers or their vendors. And so they get frustrated when their vendors or customers impose obligations or include language in their agreements or ask questions that to them seem superfluous or unnecessary or bothersome for whatever reason and slowing up the process, particularly if it comes from a lawyer, without understanding why the lawyer is asking that question. What legal and regulatory framework do they have to deal with? And I think part of the challenge, in this community, because it's working across so many different sectors and so many different technologies that the data is being aggregated into, is understanding what those legal regulatory challenges are and helping your customer, your vendor, find a solution that works for you and works for them, because it needs to work for both parties for this to work. Now, you can get frustrated, you can feel like it's just the lawyer raising unnecessary concerns, but the reality is, particularly if they're in a heavily regulated industry, they've got a lot of concerns they need to deal with, and you as a vendor or you as a customer need to help them address that if you want to continue that relationship. So that's probably the issue that I see. It's just not an appreciation of how there is no necessarily geospatial law that they have to worry about, but there's issues that other sectors are dealing with, and they need to figure out how you fit into that.
All right. Kevin, my next question is about collaboration. WGIC being an industry body, we kind of advocate for collaboration within the industry and outside to address some of the complex problems the world is facing today, and which often may require companies to partner with other organizations as well, and often foreign entities as well. So what legal frameworks should be considered when sharing geospatial data or collaborating with other businesses or government entities? Is there some fundamental frameworks that one should be aware of or one should be very cognizant about?
Well, for some sectors, I think understanding export laws or national security laws will be very important. Mm-hmm. You need to appreciate your own country's laws in terms of restricting access to data or technology to people outside your country, and that's a critical for anyone, not just for the geospatial sector, but that's probably the number one. You want to make sure you're doing that. Second of all, because of the growing concerns around privacy, and because, like we talked about, the power of geospatial information, I think you want to make sure that if you're sharing data that could potentially be used to identify someone, that you understand what the privacy laws or obligations are both in your country and in their country, to make sure that you're not somehow violating those. So those are two things. I think there's certainly intellectual property is another area. The intellectual property law varies quite a bit between countries. So understanding what protection you have there is really critical as well. And again, that's going to vary depending upon the type of geospatial information, the type of technology, the application. So that's another sort of, top of mind thing that I would suggest for people doing work, particularly on the international level. If sharing between government and industry, there's a lot of talk in this community about public-private partnerships and being able to, work together to solve some of the important issues that we're trying to deal with. That's great. But in my mind, from a legal standpoint, to have a public-private partnership, you need to understand in each country what the rules are for government to work with in a partnership arrangement with industry. It's different than procurement. It's very different frameworks that need to be complied because yes, there's revenue sharing, there's data sharing, there's complex issues that need to be addressed. It's different than just selling or licensing. So I think procurement and understanding what's involved, the differences between industry and government is very, very important. Those would probably be the main ones that I can think of at right now.
Yeah, I'm sure this is a very long conversation, but in the interest of time, I want you to throw some light on geospatial related contracts, especially in terms of the collaborative aspects of it, and how they can address data ownership, usage rights, and liability issues.
Well, I think like we've talked about, I think you need to understand your data and how it's being used, understand what country, what intellectual property rights might apply, understand what rights you're giving the person or the entity to use the data, what your concerns are from a liability standpoint, what your concerns are from a legal standpoint, what regulatory obligations each of the parties have, what the potential privacy implications are, if that's going to be an issue. So I think that requires, when I first started practicing law, contracts were generally for sales of goods, right? And so they were relatively straightforward, relatively easy to do, and because once they were over, the parties would go their separate way. When we're in a world of data as a service, software as a service, AI, licensing, public-private partnerships, where people are working together, the contract, the license agreement, the master service agreement, whatever that is, the relationship between the parties needs to be included in that agreement. Now, you can have a short agreement that doesn't include it, but then if something goes wrong, you're going to turn it over to a judge or a court or a jury to decide, or a regulator to decide who's responsible. They may not understand the technology, they may not understand the data, they may not understand the limitations. So if you want to protect yourself, that means including it in the agreement and making sure you've thought through all the ramifications. Now, I know that's not it takes time, it takes money for lawyers and other things, and I know that's not how people necessarily want to spend their money, and it's a business decision if you don't want to. But if you do, then you need to make sure that you have people understand your business and understand what you're doing, what the risks are, understand what geospatial information is. I mean, one of the challenges of geospatial information is once someone has data, they can use it for a lot of different applications. That's the power of the technology. It's other data. It's so versatile. But it may not be suitable for that application, right? It may not be timely enough or precise enough or complete enough. And so that's the risk. And how do you make sure that someone doesn't use your data in a way that exposes you to liability, because ultimately you're still the owner, is something you need to think about. Or, if you don't think about, you're leaving it to courts and juries to decide if something goes wrong. So it's a complex issue. It's not something that there's sort of one answer to, but I do think there's a growing need of the appreciation for geospatial, understanding the legal issues around geospatial. And that's, as you know, I wrote a textbook on it for geospatial professionals because there aren't many lawyers that understand this. And so I'm hoping that students will sort of get an appreciation when they work through these issues, and then maybe they can go to their lawyers with more informed questions so that they can get the responses that they want.
Yeah, that is true. Then not many people educated about the legal aspects in the geospatial industry, and that's where I think this conversation becomes even more important for us, especially for the WGIC member companies. On that note, I would like to ask you one question to close this conversation as well. In terms of where are we heading to? You mentioned that earlier the contracts were fairly simple, but that's not the case now. So moving forward, where are we heading to? And any general recommendations or guidance for geospatial companies that you would like to give?
I think two things we're headed, it seems to me, is one with AI and everything being done sort of behind the scenes.
Yeah.
It's going to be increasingly important, I think, to understand how your data is being used and who's using it, and one, to make sure that you're properly compensated for it, and two, that it's being used in ways that it's suitable for, both from a legal standpoint and from a business standpoint, right? So that's one thing. The other thing is, and I've thought about this some. I haven't really explored it any further, but I do think, and I think this will impact the geospatial sector if it does apply, if it does evolve this way. You know, we've traditionally thought about contracts as sort of just one-dimensional documents. Everything is written there, and then you maybe have exhibits that are also in the written word or maybe a picture. I can see an environment, particularly with AI and other technologies, where contracts become more 3D like, right? So you can tie, you know, certain applications and things and embed them in a contract in a way that you can, the lawyers and everyone can see what is happening and how it's developing, and in more of a real-time situation. Now that's going to take some time. It's going to take some time for the legal community. It's going to take some time for the technology, but I think it would be helpful, particularly in this context around some of the applications, if legal documents weren't static, and they were, and there's some movement of that in the architectural industry around BIM, but I can see a trend of that as well, that they become almost a different form. And I'm not articulating it very well because I'm still thinking it through, but that is, you know, when you ask the question, that is something that I've given some thought to.
Great. Thank you so much for your insights, Kevin. I thoroughly enjoyed this conversation. Very useful for the companies. Thank you so much.